Hello and welcome everyone to our webinar on Closing Loopholes, Law Changes, what every employer needs to know. Thanks so much for joining us today. My name is Dickson Wu. I'm a senior lawyer in LegalVision's employment team, and I'm joined by my colleague Emma Bucholtz, who is a lawyer in the team. Before we begin, I'd just like to flag a couple of quick housekeeping items. So firstly, you'll receive a copy of the recording of this presentation, as well as a copy of the slides to your email, in case that helps with you not needing to take notes throughout. We'll also have an opportunity at the end of the presentation to answer as many questions as possible. So we'd love for you to submit your questions in the chat box, and we'll go through as many as we can at the end. And we'll also have we've already had quite a few pre-submitted questions. So we'll also try to get through as many of those as possible. What that might mean is we may need to extend the webinar by a few minutes if necessary, but we'll see when we get there towards the end. And finally, we'd really love to hear your feedback on these webinars and on this particular presentation that you're listening into. We always love to hear from you and hear what's been helpful, how we can improve and make things better as well. So there will be a survey at the end of the webinar, a very short and quick one that you can fill out. As part of that, you can also let us know if you're interested in having a consultation with us. It's completely free, and it's just to discuss how we can help your business, maybe in light of some of the topics that we've addressed in this webinar or otherwise. If you are interested, then please just provide your contact details in the survey at the end of the webinar. All right, so let's jump into it. Today we're going to be discussing quite a few changes to workplace laws that have either come into place or will be coming into place a little bit later this year and in 2025. Now, the Australian government has made numerous workplace laws as part of its closing loopholes changes. And for the purposes of this presentation, we're just going to be focusing on some of the major workplace changes, but not going to have enough time to cover every single change that's coming into place. So I'm going to kick off with talking about the changes to casual employment. So before we think and consider the actual changes to casual employment, it's worth considering the current position and the current definition of casual employment as well. So currently, a person is a casual employee if they are offered a job, if you make no firm advance commitment that the work will continue indefinitely with an agreed pattern of work. And I'll touch on in a moment what it means to have no firm advance commitment, because that's a really key principle. But also that the employee accepts the offer, knowing that there is no firm advance commitment. So again, what is no firm advance commitment? So to work this out, when you're offering the job to a casual employee, consider a few things, including whether you can choose to offer the employee work, and it's actually their choice whether to work or not. Secondly, that the employee will be offered work when you need them to work. Thirdly, that the employment relationship is going to be described as casual. And finally, whether the employee will be paid a casual loading, so 25% casual loading, or a specific pay rate for casual employees. Now, whether the person is a casual employee is assessed at the time they're offered and accept the job. So if I give you just a quick example of this concept of no firm advance commitment, let's say we have Sam. Sam is offered a job as a shop assistant. This job was advertised by you as a casual position. And when you meet with Sam, you say that if she's going to need to work when the shop is busy or other staff are on leave, so when you need her to work. And when business is quiet, Sam's going to get less work. She's going to be offered shifts a week in advance, and those shifts will vary from week to week. She can decline shifts if she wants to, and her pay rate will include a 25% casual loading. And then she accepts the job knowing all of that. That would be an example of there being no firm advance commitment. So that's the current position. There are changes which are going to be commencing on the 26th of August this year. And under these changes, there's going to be a new definition of a casual employee. Specifically, it's still going to be relevant to consider the absence of a firm advance commitment, everything we've talked about already. and whether the employee is paid a casual loading or a specific casual pay rate. Key change is that the real substance, practical reality, and the true nature of the employment relationship will be assessed. What this means is that there'll be less emphasis given to the casual employment contract at the time of offering casual employment and greater emphasis on the relationship in practice, so how it actually plays out. Now, importantly, the new definition continues to make it clear that if employment genuinely starts off as casual, the fact that it gradually settles into ongoing and regular work will not mean that an employee automatically ceases to be a casual. That can only happen if you and the employee agree on a new arrangement or if the employee successfully pursues reclassification under the casual conversion process. This leads me to the next topic under this umbrella, being casual conversion. And again, I'm going to touch on the current position and then what the changes are going to be. So in terms of casual conversion, currently an employer, other than employers with fewer than 15 employees, so small business employers, must make an offer for a casual employee to convert to full-time or part-time employment if certain criteria are met. Specifically, this criteria is that the employee has been employed for at least 12 months. Secondly, the employee's worked a regular pattern of hours on an ongoing basis for the last 6 months. And the employee could continue working that regular pattern of hours as a permanent employee without any significant changes. Okay, so if that criteria is met and you are not a small business employer, so if you've got 15 or more employees, the current position is that you actually need to make an offer for casual conversion to an employee. Now, it's also relevant to note that an employee currently has the right to make a request for casual conversion if they meet the relevant eligibility criteria. So again, let me illustrate this in an example and focusing on that concept of a regular pattern of hours. So let's say we have Alex. Alex is a casual employee who works every Thursday and Friday night at a restaurant on a regular basis. His hours and days don't change. And over the last 6-month period, Alex does miss a couple of shifts due to being sick, but by agreement with you, he also takes a week off to prepare for his uni exams. So even though Alex has taken some time off due to his illness, due to his uni exams, this will still likely meet the definition of a regular pattern of hours because he's been consistently working Thursday and Friday nights, those consistent hours and days. Now, in light of all this, it's also worth remembering that you're not required to offer casual conversion or accept a request by an employee for casual conversion if there are reasonable grounds. And what are these reasonable grounds? Well, they include that in the next 12 months, either the employee's position won't exist, the employee's hours of work will significantly reduce, or it could be that the days or times that you need the employee to work will change significantly. The employee won't be available to work that revised schedule. So that's the current position. Under the changes which commence on the 26th of August 2024, so the same date as for the definition of casual employees, a casual will be able, after 6 months employment, or it's 12 months with a small business employer, to assert that their employment has actually ceased to be casual. Now, if you accept this, then you must engage the employee on a permanent full-time or part-time basis. Alternatively, you can either dispute their assertion or reject the proposed change on fair and reasonable operational grounds. We do have a little bit of guidance about what these fair and reasonable operational grounds are. And they include that substantial changes would be required in the way that work in your enterprise or in your business is organized, or that a switch to permanent employment would bring significant impacts on the operation of your business. Now, the new process will differ from the current position in 2 key respects. The first is that larger or non-small business employers will no longer be required to conduct a review of long-term casual engagements and determine whether to offer a permanent position. So it actually, in a sense, is less onerous on employers being that you don't actually need to conduct that review and make that assessment as to whether you need to offer casual conversion. And action will only be needed if an employee choice notification is received. So, in other words, if the employee reaches out to you and notifies you that they believe they're asserting that their employment has ceased to be casual. The second key change is that the employee can only activate this new process by claiming that their job has already become an ongoing one. So, merely having received casual work on a regular basis for the 6 or 12 months will not be enough, as it would have been under the current conversion provisions. Okay, so that's casual conversion, the current position, and the new position under the changes. One other thing we wanted to flag in the topic of casual employment is that there is an existing requirement under law which has been maintained and actually expanded, and that's the requirement to issue a casual employment information statement. So hopefully you're already aware of this if you are employing casual employees, but this statement is simply a document that's published by the Fair Work Ombudsman, and it provides casual employees with information about their conditions of employment and covers topics that we've discussed, such as casual conversion and the definition of casual employment, and actually includes the examples that I shared a little bit earlier. So at present, this statement only needs to be given once at the beginning of employment or as soon as possible after that. But now it actually needs to be given to each casual, not only when they commence work, but it needs to be reissued after they complete each 12 months of work. So something to keep in mind, probably worth marking in your calendar or having a way to remind yourself that you need to reissue that statement. The other additional requirement is that employers who aren't small business employers will need to supply it at the 6-month mark. All right, so that covers broadly the changes to casual employment. Again, if you have any questions about any of this, feel free to submit them in the chat box. I'll now hand it over to Emma to talk about some changes to contractors.
Thanks, Dickson. The Closing the Loopholes legislation will also make major changes to how contractors are classified. As with Dickson's approach earlier, I think it's really helpful to walk through the current legal position and then run through the actual changes that are coming into effect this year as well. Now, currently, when assessing whether a worker is a contractor or an employee, you will be guided by two 2022 High Court decisions called the Personnel Contracting Case and the Jamset Case. In both of these cases, it was held that the primary consideration when determining whether a worker is a contractor or an employee is the written contract between the parties, unless the contract itself is a sham. Now, these decisions provide employers with a strong layer of protection where there is a well-drafted contract in place currently. The Closing the Loopholes legislation will restore the state of the law to what it was regarding the employee and contractor distinction prior to these High Court decisions. Under the new legislation, which will come into effect on the 26th of August of this year, the same as the casual provisions, whether an individual is an employee or a contractor is to be determined by assessing the real substance, practical reality, and true nature of the relationship between the parties, not just the contractual terms. Now, this change is very similar to the changes that Dickson discussed earlier in relation to the new definition of a casual employee. The focus is now on what the relationship is in practice, so ultimately what it looks and feels like. And as well, the parties' conduct post the commencement of the contract will be really relevant in this assessment. You might hear this referred to quite regularly as the multifactorial test, and this was the name of the test prior to these decisions as well. In light of these changes, it's really important to revisit what genuine contractors look like. Unlike employees, contractors typically run their own business, have a high level of control regarding how and when they work. They generally bear their own risks, use their own tools, and in lots of cases, they will generally invoice for the work that they complete, subject to payment of that invoice as well. Now, in light of these changes, it's really important to think about practically how they will affect your business and some key considerations you should always have in your mind. Now, what we recommend is that you assess your engagements with contractors and consider whether the contractor looks and feels like an employee in reality. Now, really importantly, no one factor will be determinative in this assessment, and there's no exhaustive list of factors in the new legislation, unfortunately, to guide us. So the multifactorial approach, which has historically applied, will be helpful in guiding us on this. Now, what would be really important to consider is the extent of control over that worker, whether the worker is provided tools or required to wear uniforms in the provision of their services, whether the worker can delegate out their work, so essentially subcontract to another worker or contractor, whether the worker is paid a regular or periodic wage, like an hourly rate, or whether their payment is contingent on the completion of a specified task or project, which is often referred to as a fixed fee arrangement. Now, whilst we are yet to see the law actually tested in the courts, we would consider the lines to be blurred potentially in a contractual relationship where the contractor is engaged for, say, 38 hours per week and paid a regular salary or wage on that basis, or even in circumstances where the contractor is offered what would typically be employment entitlements, for example, paid personal or annual leave entitlements. We do always recommend that you seek advice on your specific circumstances, as this assessment won't always be straightforward, and we may need to look at the totality of that relationship in practice as well. Now, I do think it's also helpful just to run through the main risks associated with misclassification, and this might be something you're already aware of, as the position hasn't changed in this respect, but helpful nonetheless. Now, employers who are found to have misclassified an employee as a contractor may face a claim for employee entitlements. So this could be for any unpaid annual leave that has been accrued over the term of that engagement, or potentially for wages, so national minimum wage wages that the contractor would have been entitled to if they were actually an employee of your business. Beyond this, where your company or business engages in sham contracting, which is in breach of the Fair Work Act, you may also face financial penalties. Now, interestingly, you may have experienced a situation where an individual worker prefers to be engaged as a contractor. Now, in our experience, and I'm sure Dickson can speak to this too, we're often instructed that contractors prefer to be contractors as they can work for multiple businesses, they can generally manage their own affairs, including their tax affairs, and they generally like that level of flexibility. Now, this is absolutely fine, but the new amendments do also allow a contractor to opt out of the application of the new definition of an employee. And that is only if the contractor earns what is called a high income threshold amount. Now, unfortunately, the legislation hasn't confirmed what this amount will be, so we do need to look out for this and watch this space, as it might trigger an assessment of your contractors and what they're earning to consider whether they can opt out or not. Importantly, not all contractors will have the ability to opt out based on that high income threshold. And also, an individual can revoke their decision to opt out at any time. So it shouldn't necessarily just be a complete safeguard. Beyond this, it is important to remember that simply because a contractor prefers to be engaged as a contractor does not mean that the arrangement is lawful. You may still be engaging in sham contracting, even where the contractor has agreed to or requested the arrangement. Now, ultimately, it is your decision whether you are comfortable taking on this level of risk when engaging a contractor who exhibits some characteristics of an employee. Now, as employment lawyers, we can assist with that assessment and ultimately provide some advice on your risk exposure. So we do recommend that you consider that as well. Now, just moving on to some specific entitlements to consider when talking about contractors, it is really important to remember that an individual who has been classified correctly as a contractor is not entitled to or owed the same entitlements as an employee under the Fair Work Act. For this reason, we don't recommend that you offer your contractors what would otherwise be employee entitlements. So those things I did refer to before, like paid annual leave or paid personal carers leave, as offering these sort of entitlements will increase the risk of misclassification in light of the new changes to the law and the fact that we can't necessarily be protected by a well-drafted contract anymore post 26 August. Now, importantly, if you are able to offer your contractors these entitlements or are thinking about it, it might be worthwhile actually reevaluating that relationship completely and considering whether it makes sense for them to be an employee. That, of course, comes with additional obligations like compliance with the Fair Work Act in other respects, but it may mitigate some risk for you in this space. Just as a final note here on the contractor piece, these changes don't affect the determination of employment status for other laws, such as superannuation, tax, or workers' compensation. And so we do recommend, again, that you seek advice in respect of those unique factors. So that is the end of my discussion about contractors. I will hand back to Dickson now just to talk through the new right to disconnect under the Fair Work Act.
Great, thanks so much, Emma. So the right to disconnect, a very hot topic, one that we received quite a few pre-submitted questions on as well. So definitely a lot of interest in this space. So to kind of summarize what this right is and some key considerations, the first thing to note is that the key date is again 26th of August 2024, or it's actually a year later, so 26th of August 2025 for small business employers. That's when this right commences. And this right is it enables employees to have this right to disconnect outside of work hours. Specifically, they're going to have a right to refuse to monitor, read, or respond to contact or attempted contact from you as their employer or a third party, such as a client, outside their working hours, unless that refusal is unreasonable. So, in determining whether a refusal is unreasonable or not, there are a few factors that need to be taken into account. I'll run through these. So, the first is the actual reason, purpose for the contact. Secondly, how the contact is made and the level of disruption that contact causes the employee. Another factor is the extent to which the employee is compensated to remain available to perform work during the period in which the contact is made, or they're compensated for working additional hours outside of their ordinary hours of work. We'll also take into account the nature of the employee's role and the employee's level of responsibility, as well as the employee's personal circumstances, such as family or caring responsibilities. So if I give an example here, don't think that this right to disconnect, and again, taking into account all of those factors that we just ran through, should be able to prevent employees from being contacted in relation to emergencies. So, say I'm in charge of needing to open up the office when there is an emergency, when something's happening in the office. That might be outside of my hours of work as such, but very much part of my responsibilities, my role. I'm compensated for it, or it's considered in my compensation. Well, that doesn't mean then suddenly, because of this right to disconnect, if there is an emergency that occurs and my supervisor or my boss contacts me to sort that emergency out, that I'll be able to refuse it. I think it's likely that that would be an unreasonable refusal in that scenario. Another one that might come up in your context could be, again, in slightly more of the urgent and emergency type situation of needing to contact employees about shift covers. If you find out that an employee tomorrow morning is unwell, unable to attend or work their shift, you need to contact, say, a pool of casual employees to see if anyone can help cover their shift. I think that's another example where you can absolutely do that. And also remembering that the right to disconnect isn't necessarily stopping you from making contact. It's about whether the employees actually have that right to be able to refuse that contact, to refuse to monitor it, to read it, and to respond to it as well. Now, if there is a dispute between you and your employee in relation to the right to disconnect, the Fair Work Commission has the ability and the power to deal with these disputes. And the way they do this could include making orders to stop an employee from refusing contact, or actually to stop you as the employer from taking certain actions. Now, as next steps in all of this, this is something that's still to come into place later in the year. But for now, you might want to consider whether those late night emails or weekend text messages are absolutely essential, or if they can actually wait until the next business day. Consider the cost of the intrusion into your employee's personal life against their total remuneration, maybe their seniority, their role, in assessing whether it's going to be reasonable to expect them to respond to out of hours contact. And finally, you can also just consider opening a dialogue with employees about when they feel comfortable being reached outside of work hours. You might find that some employees may not mind responding to such contact, while others want total separation. So that's just a high level overview of the right to disconnect. Again, I imagine that there's going to be some questions on this, so we'll try our best to answer them. But for now, I'm going to hand it back over to Emma just to address a few other small but key changes.
Thanks so much, Dickson. What we will talk about now in these next couple of slides are some other key changes that are coming into effect or have already come into effect under the Closing the Loopholes legislation. And really importantly, as flagged by Dickson, this list isn't exhaustive. There are several changes that we have seen. So we do really recommend that you take a look at our publications, that you do some reading. The Fair Work Ombudsman have some really helpful resources that you might want to review post this webinar as well. Now, one of the changes that we would like to highlight as really relevant and important is the criminalisation of intentional wage underpayments. So on the 1st of January 2025, intentional underpayments of wages by employers will become a criminal offence. Now, an offence will be made out when an employer is required to pay an amount to or for the benefit of an employee under the Fair Work Act, an industrial instrument, which might be a modern award or an enterprise agreement, or by an order from the Fair Work Commission, and the employer fails to do so. Now, the Fair Work Ombudsman will be primarily responsible for investigating the new criminal offence, and the legislation does, interestingly, actually provide pathways to encourage employers to self-disclose conduct that may amount to an offence to avoid prosecution. Again, this isn't an advice to say just because you disclose doesn't mean there won't be responsibility or prosecution. It's just that the legislation does path these ways forward as an option. Now, depending on the level of cooperation of the employer and the gravity of the offence, the employer and the Fair Work Ombudsman may be able to reach a cooperation agreement, and this may be reached in lieu of prosecution. Notwithstanding this, where the Fair Work Ombudsman determines that an offence has occurred and has not been rectified, it may still take non-punitive action like issuing a compliance notice, and that notice may be for the employer to rectify the underpayment. They may also take civil action or refer the matter to the Commonwealth Director of Public Prosecutions or the Australian Federal Police for consideration and prosecution where appropriate. Now, importantly, there won't be a criminal offence made out where the underpayments are accidental, inadvertent, or based on a genuine mistake. As an example, a genuine mistake may occur where there has been a miscalculation of an entitlement, and this miscalculation is a really genuine mistake and not something that you have conducted intentionally or as an avoidance tactic. This doesn't mean necessarily that employers can turn a blind eye to underpayments. So, of course, we always recommend that you conduct regular audits and keep up to date with increases to minimum pay obligations as well. So, we often see them come into place in around July each year, and that's to awards and as well to the national minimum wage. So, keep an eye out in the next couple of months for that as well. Now, the wage theft offence will carry penalties, and these penalties aren't insignificant. So there may be fines for body corporates up to a maximum of 3 times the underpayment amount, where that amount can be determined by a court, or 7.825 million, where this amount can't be determined. So this is very significant amount. Of course, that's the upper remit of those penalties, but it is a lot to think about. Now, additionally, individuals who are involved of a breach may also face up to 10 years of imprisonment or fines up to a maximum of $1.565 million. So that wraps up my discussion around the changes to wage theft. Now, another really important change that has come into effect, and this is already in place as of the 15th of December last year, is that there are new, stronger discrimination protections under the Fair Work Act for employees who have been or are being subjected to family and domestic violence. Now, specifically, an employer is expressly prohibited from taking adverse action against a current or a prospective employee, so potential candidate, because of that person's subjection to family and domestic violence. Now, some examples of adverse action may include dismissing an employee, not hiring that prospective employee, or altering an employee's job to their detriment. So it could be reducing their hours or cutting their shift or their pay, for an example. A failure to comply with these provisions may result in your employee or your prospective employee bringing a successful general protections claim against your business, with the risk of awards of compensation and civil penalties as well. And just to turn to the final of the changes we will be running through today, there are also new small business redundancy provisions which may affect your liability for redundancy pay as an employer. So under the Fair Work Act, small business employers, so those with less than 15 employees, are not required to pay redundancy pay under the National Employment Standards. And this has been the position for quite a long time. Now, as of the 15th of December last year, a non-small business employer that becomes a small business employer with less than 15 employees may still be required to pay redundancy pay to redundant employees where the business is bankrupt or in liquidation due to insolvency, and the business became a small business employer as a result of one or more employees being terminated in the 6 months prior to the bankruptcy or liquidation. Now, as you can see, this change operates to prevent employees from decreasing their workforce in the lead up to a bankruptcy or liquidation to become a small business employer and avoid those redundancy pay obligations. So again, these are basically anti-avoidance provisions that we're seeing in the Act. So that wraps up the summary of the key changes. Of course, we can assume that there's probably a lot of questions around the practical application of these changes to your business and what you should be thinking about as well. So just to give a bit of a summary of some of the practical tips and recommended actions for carrying out your obligations under the new legislation, we do recommend that you consider how these changes will affect your business day to day. Importantly as well, these changes are really reflective of a broad policy shift in government, and so just be on notice that we may expect to see additional changes in the future. These provisions and the new changes in legislation were passed very quickly in the last couple of years, so it can happen quickly as well. So always keep an eye out. Now, in light of the Closing the Loopholes legislation, we recommend that you conduct a thorough review of your contractor agreements and engagements to ensure that any misclassification risk exposure is managed. We also recommend that you closely consider any requests from your casual employees to convert to permanency in line with the new employee choice framework that Dickson walked through earlier. We also recommend that you review your expectations around out-of-hours contact within your business and consider whether you can implement practical changes to limit this out-of-hours contact, or potentially set some parameters for your managers or employees around what's reasonable and what's perceived as reasonable within your business as well, considering all of those factors that Dickson outlined, compensation, seniority, etc. Beyond this, and in light of the other changes we ran through in the last part of today's presentation, we do also recommend that you conduct regular audits of wages and entitlements to ensure that you aren't underpaying staff, and that you seek advice if you are looking to reduce headcount before heading into liquidation or bankruptcy. Hopefully this doesn't happen, but if it does, please get in touch, and of course we can help you navigate the new risks associated with that. So that concludes the main part of our webinar. We appreciate your tuning in today as we walk through several changes. You might find our publication on the current slide useful as a quick reference to the changes we've discussed today. I will just give you a minute to scan the QR code on there, but you can keep that on file and of course refer to it as you need. You may also be interested in our upcoming event, which will specifically address your obligations under work health and safety legislation, with a specific focus on preventing sexual and gender based harassment. You can see the details of this webinar on the screen now, and of course, just register as you have with our event today. So we're going to review and answer some of your fantastic questions shortly. We've got quite a few coming through, so I will let Dickson take some time to take a look through those as well. Now, while you do submit them, and please continue to do so, we'll take a minute to tell you about our LegalVision membership. By becoming a LegalVision member, your business gets unlimited access to our full team of over 100 specialist lawyers for all of your business's usual needs. It's like having your own in-house counsel for a fraction of the cost. So our team can assist you with unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, and unlimited domestic trademark registration, as well as much, much more. We can't list them all out today. We do also offer a dedicated service for in-house teams and general counsel to manage your high volume business as usual legal tasks. To learn more about how membership can help you, you can request a free consultation, as Dickson flagged earlier, when the survey appears at the end of the webinar. We do encourage you to do so if you are interested in exploring this further. Great. So now we will answer some of the great questions that you have submitted. Of course, please keep them coming. I will just have a quick look here just to see what we can ask Dickson. I'll give him a minute to just prepare that as well. Okay, so we've had a great question come through just around casual conversion. The specific question here is, say a casual is eligible for full-time or part-time conversion. Does the work schedule offered need to match the shifts the casual has worked in the past 6 months, i.e. if they work Saturdays and Sundays consistently, would the full-time or part-time offer of employment be for Saturday and Sunday work only?
Yep, and it's a really good question, and the short answer is yes. So, in terms of the permanent part-time or full-time employment, in this case, part-time employment that you're offering, it just needs to, well, the requirement is for it to match the regular pattern of work that they've been performing, say, in the last 6 months, or at least the last 6 months. And so, yeah, if that was full-time hours, you'd be offering them full-time employment. But if it was part-time, then again, just matching that pattern that, in a sense, has already existed.
Great. Thanks, Dixon. We've had another great question come through around casual employees. And that question is, what are my rights and responsibilities regarding terminating casual workers?
Yep. So, in terms of casual employees, the first thing to remember is that because of the, I guess, ad hoc nature of casual employment, and in the sense the way it's designed to be and defined to be, casual employees' employment actually ceases or ends at the end of each shift or engagement. So, in terms of terminating their employment, it is quite different to, say, a permanent full-time or part-time employee, and usually carries less risk. However, the kind of main caveat to that is if they are what we call a regular and systematic casual. So if they have been working a regular pattern of work, then they might have access to what we call an unfair dismissal claim. So that if you did stop offering them shifts or giving them work, um, subsequent to them having worked a very regular and consistent pattern or number of hours with you, then yeah, there could be scope for them to bring that claim and associated risk with that. I don't fortunately have the time to go into a lot of detail on that right now, but if that's something that concerns you and that you need some help with, then I definitely recommend yeah, seeking some additional advice or help on it.
Great, thanks, Dixon. We'll talk through one last question around casual conversion. And that question is, do we still need to offer casual conversion until the 26th of August this year?
Yep. Yeah. So again, the short answer is yes, until the changes are implemented, and that 26th of August date this year, that current position, the current requirements still stand. So if those relevant criteria are met and you're not a small business employer, then yeah, that position, that current requirement still stands.
Great. Thanks, Dixon. We'll move on to a couple of questions now around the changes to contractors. We've had a great one come through, and that question is, what's the difference between contractors and maximum term or fixed term contractors? So, for example, engaging someone on a 12-month fixed term contract for a parental leave cover, but the individual receives sick leave, paid leave benefits, and otherwise might feel like an employee.
Yep. Yeah, so I think on this, the first thing to say, it's important to differentiate between contractors and employees. And so, what I mean by that, and I suppose a big topic that we've addressed is sham contracting, where we've misclassified or disguised and an employment relationship as a contractor arrangement. I think here, if there is going to be an individual who is being engaged for, say, a 12-month fixed term or a maximum term period to cover for someone else, but they are actually going to be receiving sick leave and paid leave entitlements, then I definitely consider whether you'd actually be employing them in that scenario. So, um, as you can have a maximum term or a fixed term employee, and under that, they are receiving similar entitlements, the same entitlements as your part time, full time permanent employees. So, I suppose to help try and answer the question, the kind of key difference is you can have a fixed term contractor arrangement, but if you were to give them leave entitlements such as sick leave and paid annual leave, then that's definitely going to be a factor that's considered in the question of, are they a genuine contractor, or should they actually be an employee and receive employee entitlements?
Great. Thanks, Dixon. We do have another really great question around contractors. The question here is, what would be included in employee-like benefits? Would access to the organization's EAP service be included in this, or is it just employee entitlements?
Good question. So I think first thing to say is when it comes to thinking about employee-like entitlements, I would say that we'd be considering things like other benefits, employee-like benefits. If your contractors receive the same types of benefits that, if your contractors receive the same types of benefits that employees do, then yeah, it starts making them look like part of your team, part of yeah, the rest of your employees. And an example of that would be access to EAP. Now, in saying that, it's really important to remember, as Emma mentioned, that there's no one determinative factor here. So let's say you did have a contractor and you really just wanted to give them access to your EAP so that they can chat through a traumatic event or maybe some mental health issues that they're going through. Yes, while that might be one factor that will be considered in the full picture, that in and of itself shouldn't mean that, well, they've got access to your EAP, therefore they are an employee of your business, and therefore you are liable for sham contracting. So it is a mix of a legal and kind of practical commercial decision for you. But yes, we do need to consider it holistically, and there's not one factor or entitlement that is necessarily determinative.
Thanks, Dixon. We'll just move on to a couple of questions about the right to disconnect. We've had some great ones come through there as well. Now, one of the questions here is, do we need to update our policies and promote the legislative changes to all staff for the right to disconnect?
So I'd say you don't necessarily need a right to disconnect policy. However, if that's something that you would like to have in your business, then you can certainly have one. It wouldn't be unlawful to have a right to disconnect policy. I suppose in considering whether to have one or not, a lot of this will surround what are you actually planning to include and cover in it. If it's a policy that simply restates or includes, in a sense, a summary of what the law says, then that's absolutely fine. And if that's something you want to make employees aware of, then that's okay. It's not going to add anything to the law as such or to the position, but you're welcome to do that. If you want to, in a sense, try to tailor it to specific situations in your business, in your industry, even, then that could be a documented place to address that as well. But again, consider how you do that, and I suppose ensure that whatever you put in there isn't against the requirements of the law.
Perfect. Thanks, Dixon. We will run through a couple more questions. We are conscious that we are close to time today, but we will continue for a couple more minutes just as we've got a lot of questions to work through here. So feel free to stay online if you are able to. We've got another great question in respect of the right to disconnect. And that question is there an income threshold where an employee is not included in the right to disconnect?
Another great question, and probably sparked by all the talk about high income threshold that we've mentioned. So the answer here is there's no income threshold, which would mean that an employee is not included or entitled to that right to disconnect. However, if we remember, one of the considerations, one of the factors that are taken into account is the employee's remuneration. So if they are earning above the high income threshold, about 167K right now, that's definitely one of the factors that are going to come into play as to whether the employee can actually refuse the contact.
Great. Thanks, Dixon. Maybe one or two more today. We've got a great question arising, I'm assuming, from our discussions about the redundancy pay changes. And that question is, are the number of employees referred to in the small business employer headcount full-time employees or other employees as well?
Yep. Yeah. So I think this question relates to when we've been talking about small business employer, and we've given the number of 14 or fewer employees. So with that definition, to go into a little bit more detail, it is you do start with considering just your full-time and part-time employees. So casuals are excluded from that headcount unless they are regular and systematic casuals. So if they are working a regular pattern with you, then they would need to be considered in that headcount. The other thing that's really important to note here is that any employees of associated or related entities are considered here as well. So this could even be an overseas related entity. Um, the number of employees that that entity has needs to be factored in as well.
Okay, fantastic. And we might just have time for one more question today. And this is another great question, just to revert back to casual employees. Sorry, Dixon, to revert back there. But
All good?
this great question is, would having the casual employment information statement on the shared drive be sufficient in providing this to an employee? Or do we actually need to provide it to casual employees individually?
So I'd say for this one, the law requires you to actually give the information statement to the employee. And so there's going to be a question of if you simply put it on a shared drive, whether you're actually giving it to them. Do they have access to that shared drive? Are they made aware that that's there as well? So definitely the safer option here is to actually provide it to them and actually keep a record of that as well, so that you'd be able to show that you've actually given it to them and you know the exact kind of point in time as well. So I think in terms of timing, I might just very quickly, if I can rattle through a couple of more, I'll do that just as a very high level, and then unfortunately we will need to wrap up. So I think there were a couple of questions around paying contractors superannuation. My really quick answer to that is there are situations where genuine contractors are entitled to superannuation, and that's actually under a separate kind of piece of law, superannuation laws, so not employment laws as such. And so on that, if you do have questions about that, really recommend speaking with your accountant or a tax lawyer, and they'll be able to give you some more insight on when contractors are entitled to superannuation as well. Let me just see if there's anything else that I can just really quickly rattle through. Look, again, thank you so much for all of your questions. They're really relevant and yeah, really show that you're paying attention to a lot of these changes that are happening and then how they affect your business as well. But I think for now, we're just going to have to wrap up there. Sorry if I didn't get around to answering one of your questions. Um, Again, if you'd like to claim that free consultation with us to discuss how we can assist you through our membership, then feel free to leave your details with us. And again, while this is a free webinar, I really value your feedback. So there is a survey that's going to pop up very shortly. So really appreciate it if you can just complete that and leave your feedback. So again, thank you so much for joining us. We hope you have a great rest of your day. And yeah, hopefully see you or speak to you again soon.
Thank you.